I'm Madison Smith.
I'm Harry Gale.
And this is Next Era Politics.
This week, our topic is Title IX reform, meaning we'll be talking about the legal context regarding sexual assault on college campuses nationwide. Policy-wise, this is a controversial but nonetheless important issue. It makes people uncomfortable, but it is a vital conversation we must have in order to determine how we can best protect victims and ensure a fair system. So, what's going on?
The new interim guidelines from the Department of Education are changing Obama-era regulations, and there are 4 big alterations. Number 1, these new guidelines give colleges the ability to modify evidence standards from a preponderance of evidence to clear and convincing, meaning that the evidence against the accused needs to be more concrete. Number 2, they also lift a 60-day cap on the length of investigations. Number 3, they allow for a modified appeals process, either for both parties or accused students only. And number 4, they let the college have informal resolutions like mediation with the consent of both parties.
So, we want to break everything down and make sure we contextualize what this means for Title IX. It's important to remember that these are interim guidelines, and they give schools a lot of flexibility in terms of adherence. At this point, campuses haven't changed anything regarding to their rules, but that'll change once official guidelines are announced. Now, let's get down to the details with what's happening and why the Education Department is making these changes in the first place.
So, what specifically is Title IX? It was passed in 1972 as a way to curb sex-based discrimination in education. Court cases throughout the 80s have expanded the interpretation of the law to include sexual assault, which led colleges to develop conduct procedures based on those guidelines. The Obama administration's Dear Colleague letter in 2011 was the most recent outline, cementing the Title IX system as we know it today. These guidelines aren't perfect, and since their implementation, both sides of the aisle have proposed changes.
Last year, for example, the American Association of University Professors called for colleges to return to using a clear and convincing standard when determining Title IX violations, just as the new guidelines suggest. Responding mostly to concerns that the existing Title IX system violates basic due process rights, Betsy DeVos has created a task force to overhaul the Title IX guidelines. The Dear Colleague letter lowered the standard of evidence required to find someone guilty of a violation, and recommended against allowing the accused to directly cross-examine a victim. Colleges were also encouraged to implement sanctions on the accused in order to protect victims. These recommendations are under review right now by DeVos. News that the Department of Education was rescinding these Title IX guidelines was widely criticized by Title IX advocates, with many indicating that college campuses would become less safe and that a higher standard of evidence discourages already low reporting.
While no colleges have changed their existing sexual assault guidelines at this point, some administrators welcome the lifting of rules recommending that Title IX investigations should last no more than 60 days. They argue that allowing investigations to last longer should improve their thoroughness and get better results for the victims. But there is agreement, though, with the concerns of activists that the higher evidence standard will be detrimental to victims. This specific part of the system is at the center of the controversy over Title IX guidelines, with DeVos concerned that students can be accused of sexual assault without the ability to adequately defend themselves and might be judged as violators under a weak evidence standard. Emily Yoff, writing for The Atlantic, pointed out that some schools like Penn State say that adjudicators should rule that a violation occurred if there's a 50.1% chance that someone did it. And even if they have considerable reservations about their decision, they should still rule that they did it.
Activists believe that because sexual assault cases are not formal criminal proceedings, the clear and convincing standard is not appropriate. Betsy DeVos and the Department of Education, however, say that the current system doesn't use the same protections guaranteed to defendants in civil courts, and that the objectivity necessary in these kinds of cases isn't always there.
For example, the Dear Colleague letter does not obligate colleges to provide the accused with a written notification of the investigation and the charges against them. So someone accused of a Title IX violation can immediately have restrictions placed on them as to where they can go and at what times without even knowing the details of their situation. They are also not allowed to directly cross-examine their victims or know what adverse witnesses have testified against them. Activists say that the point of all these restrictions is to limit contact between the victim and the accused in order to prevent further trauma. They argue that victims are rarely given the support and dignity that they deserve when seeking justice, and that due process fails them as well. Betsy DeVos makes an important point about it being our duty to ensure fairness and transparency for the accused. However, she forgets that the challenges facing victims also fall short of the spirit of due process embodied in the Constitution, that we all deserve a fair hearing. Authorities too often will act as if a victim was asking for it, and minorities face institutional racism, homophobia, transphobia, and other stereotypes that devalue their testimony. Due to the lack of informing the accused of criminal proceedings and the stereotypes placed on the victims that inevitably devalue their testimony, the current system we have does not benefit either party when it should benefit the victim.
The system clearly needs to be revised. However, DeVos's reforms lack the victim-centered system that the Dear Colleague letter provides. Victims are already denied justice and have to see their perpetrators often walk away free. The challenge is not just in creating a system that ensures the best protections for the accused, but also in ensuring that the informal challenges that destroy the ability of victims to seek justice are also overcome. This is the reason why the system needs to be revised, but also why the current victim-centered system must remain. In the meantime, the Education Department will continue working on a formal guideline that will probably be implemented within the next 12 to 18 months. These guidelines will be mandatory, unlike the temporary guidelines we have now. In the end, we hope that even though this administration has a real problem with sexual assault issues, we're cautiously optimistic that some good might come out of this in the form of a compromise between the Dear Colleague letter and DeVos's reforms. This way, we could ensure the perpetrator's constitutional rights and the victim-centered system can remain.
The Education Department should remain respectful to everyone, exercising good judgment when issuing new guidelines for some of the most vulnerable. We all want justice for the victims in the clearest terms, and we all want an equal system, one that will protect the innocent, deal with the guilty, and be able to clearly distinguish between the two.
This is Next Era Politics.
And we'll see you next time.